No, she doesn't understand. Allegedly, you had methamphetamine on or about your person, and allegedly, it may have been contained within something that qualifies, aka a clear plastic bag, that qualifies as paraphernalia in the state of Florida. And allegedly, you were operating a motor vehicle without allegedly having a driver's license. You understand that?
I understand the driver's license, yes, sir.
Okay, well,
possession.
I didn't say it was yours. Did I say it was yours? I said you've been charged with.
Right.
Nobody's asking if you did it. I'm just asking if you understand what the charge is.
No.
Yes or no?
No, sir.
Okay, then we'll bring you back tomorrow when you understand.
I was hoping I'm not from this state. This county. If I can just resolve everything today.
You got a parole hold. You wouldn't get out anyway.
You got nowhere to go, man. So, do you understand the charges against you or not?
I understand they charging me with it, yes, sir.
That's all you got. See how easy that is? I don't know why do we have to go back and forth about it?
It's not easy when you're in my shoes, sir.
It's easy it's a yes or no question. Do you understand?
I don't agree to the contract.
Nobody's asking you to admit to anything. I just need to make sure you understand the charge.
I'm a proud citizen, sir.
I'm shocked you're
UCC bubbles.
Oh, UCC? Oh, I love it.
The video opens with a warm welcome as the narrator sets the stage for today's content. 4 different sovereign citizens facing 4 separate judges, including the notorious Eric Martin. The host introduces the theme of the video while simultaneously thanking today's sponsor, Extra Wallets, highlighting personal experience with their products. From travel duffels to smart wallets, he emphasizes their security features such as RFID protection, GPS tracking via apps, and reverse find technology that can locate a phone using the wallet. He ends the sponsorship segment by encouraging viewers to use a discount code and explore the growing ecosystem of sleek, personal smart devices.
Crap in one hand, hope in the other, and see if that helps. On set at 5,000 the meth, 1,000 paraphernalia, 500 on the driver's license, which oddly enough, the Supreme Court said you do need to drive. Court date is February the 17th at 9 o'clock, but you're not going anywhere because you got that probate or that parole.
Step to your right. So the T.
Mr. Fox, when you sue me, make sure you spell it with 2 N's. I want to make sure that the AG's office gets involved.
You don't have to worry about that, sir. I'm peaceful.
Sign where the light is for your copy of that.
The action begins in Florida, where Mr. Fox faces charges of possession of paraphernalia, methamphetamine, and driving without a valid license. The judge systematically explains the charges and repeatedly asks if Mr. Fox understands them. The exchange quickly highlights the tension between the legal system and the sovereign citizen mindset, as Mr. Fox repeatedly refuses to engage with the court in a standard manner. Despite his non-compliance, the judge remains calm and methodical, emphasizing clarity and public accountability while setting fines and future court dates. This clip demonstrates the legal system's patience and precision in handling non-traditional defendants.
It's off the 11 o'clock calendar. Mr. Calzada, could you please turn on your video for me?
Yeah, hold on 1 second.
All right, good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with the case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you please tell me?
Well, I'm here physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well, it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
After the initial hearing, the narrator reflects on the absurdity and entertainment value of watching Mr. Fox's interactions. The judge's calm yet firm approach is contrasted with the defendant's noncompliance, showing the importance of courtroom decorum. The host humorously comments on the judge's handling of sovereign-style arguments, reinforcing the gravity of the charges while highlighting the surreal, almost comedic, resistance to standard legal procedures. Viewers are reminded that the court's goal is clarity, not humiliation, even when dealing with unusual legal strategies.
And you guys were all doing Snohomish County prisoners. Pretty busy, huh? The sheriff even said it's pretty busy. The court has to file a 1099-C. How you file a 1099-C for that bond? You don't need voter approval for that, don't you, those bonds? How much are the bonds?
Mr. Calzada, I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So
then what am I doing here then? Hold on, what am I doing here?
well, right now you are not responding to my questions. So
Well,
I'm
you're
going
not
to have you
responding to any I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything.
The scene shifts to Bothell, Washington, where another sovereign citizen, Mr. Carter, faces arraignment. He refuses to state his full legal name or consent to the proceedings. The judge patiently explains the requirements and sets a new hearing date, emphasizing that personal beliefs cannot override court mandates. The narrator notes the defendant's attempts to assert non-consent and the humorous tone of the interaction. The clip captures the clash between legal procedure and the often nonsensical sovereign citizen arguments, providing viewers with both insight and entertainment.
that you understand what's
All
going
right, great. I'm glad. It's definitely implied, isn't it? It's not expressed. It's implied.
December 31st at 1:30 in person.
December 31st at 1:30, I'll be there.
Very
So you're here on the Martin matter, correct?
Yes, Judge.
Let's go have a conversation outside.
Okay, so everyone tell me.
All right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
Yes, good morning, Judge Donna Silva on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I was making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I can adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements. You're talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me. So,
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything you keep doing. All of your little negative comments, things that you want to say about people. And you think you're the smartest person in the room and that you have some sort of special juris doctorate.
Eric Martin, a recurring court figure, appears in Judge Slovin's courtroom for a bond violation case. The judge addresses Martin's history of uncooperative behavior and his court-appointed attorney's motion to withdraw. Through direct and stern questioning, the judge warns Martin against making disparaging comments while clearly explaining legal options. The host notes Martin's repeated attempts to manipulate the courtroom narrative and how the judge skillfully limits disruptions while upholding procedural fairness. This clip underscores how courts balance patience with authority when faced with difficult litigants.
It comes to things, and you talk about that, and so Mr. Gizicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. Do you want, all I asked you was this. I didn't ask you to give me a commentary about Mr. Gizicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney, but I want to state also that if it was recorded, that we would state it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this: do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. Which is what is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you'd like. Or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without.
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
Well, I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. Well, I don't say for the most part, maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a.
The court continues to clarify Martin's choices: accept a new court-appointed attorney, represent himself, or hire private counsel. Despite Martin's elaborate commentary, the judge repeatedly demands a simple, direct answer. The host explains the importance of this segment as a lesson in courtroom compliance, showing viewers that refusing to follow procedural instructions only prolongs and complicates legal outcomes. The judge eventually grants a new attorney, demonstrating measured authority while allowing the defendant his legal rights.
Formal hearing in two different cases that arise out of one citation, and those
Correct.
two cases are both entitled "The People of the City of Battle Creek" versus Roosevelt LaShawn Williams. Is that your name, sir?
That is my name.
Basically, what happens is you were issued one citation. It had two violations listed on it, so it became two different cases, one with an A and one with a B at the end. But we have one informal hearing scheduled for both of those cases because they both arise out of the same transaction, so to speak. And I guess, Officer Kellums, is there anything before I begin?
No, sir.
All right. Mr. Williams, you're here because you were issued a citation. And in each of those two cases, so for each of those violations, you have three possible responses to the citation. You can first admit responsibility, be assessed the fines and costs, and be done with it. You could, as a second option, admit responsibility with an explanation, hoping that the explanation would cause the court to decrease the fines and costs a little bit. Or you can deny responsibility and have your hearing. It's my understanding that as to both cases, you wished to deny responsibility. Is that correct?
That is correct.
Okay. Well, here's how the hearing works. First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay. And same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof. And in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S.?
The video moves to Michigan, where Roosevelt Williams faces 2 traffic-related civil infractions, expired registration and lack of proof of insurance. Magistrate Heist explains the process of admitting responsibility, denying responsibility, or providing an explanation to reduce fines. Williams challenges the legal definitions, citing U.S. Supreme Court precedents and claiming sovereign citizen exemptions. The host highlights the disconnect between these arguments and established law, emphasizing the court's role in upholding statutory requirements while calmly addressing erroneous legal interpretations.
The Battle Creek Police Department. When I observed the vehicle that Mr. Roosevelt was driving, I observed that it had expired tags on the vehicle. I then conducted a traffic stop on Fountain Street near Meacham Ave. Found Mr. Williams to be driving the vehicle, where I issued him the citations. When speaking with Mr. Williams, he could not provide insurance, and his tags were expired.
Okay. Do you happen to know when they expired?
I do not off the top of my head, sir.
Okay. What made you think they were expired? The wrong color and the wrong year on the plate itself, or some?
Yes, sir. Yes, sir.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to that he was traveling, and to drive a vehicle, you don't have to have insurance. Something regarding Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, I'm going to interrupt you just for a second. Are you telling me that a case at 769 Fed 2nd, 1344 indicates that all laws are unconstitutional?
All codes, rules, and regulations. Yes, sir. Rodriguez v. Ray Donovan. And if I'm not mistaken.
And you said that was Department of what?
U.S. Department of Labor.
Okay. U.S. Department of Labor doesn't publish decisions in the Fed 2nd. Can you tell me a little bit more about the case? what was that issue in the case?
It was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating in commerce, to which I informed the officer that I am not operating in commerce as stated in USC 18 USCA 31 paragraph A6 states that a motor vehicle, the term of motor vehicle meaning every description of carriage, contrivance, propelled or drawn or mechanical powered and used for commercial purposes. This is what Title 18 USCA Section 31A6 states or defines.
Williams presents detailed sovereign citizen arguments, citing misapplied federal codes and prior Supreme Court cases to claim that motor vehicle regulations do not apply to him. Magistrate Heist systematically deconstructs these claims, clarifying that state laws govern motor vehicle operation, registration, and insurance. The narrator provides context, explaining why these arguments are legally irrelevant while also noting the predictable patterns in sovereign citizen reasoning. This clip serves as an educational segment for viewers interested in how such defenses are evaluated in court.
Motor vehicle is, and an automobile
Right.
under Michigan law is a motor vehicle. But okay, continue.
Right, it's a motor vehicle which is described as anything, even by the Michigan compliance statute of 751, which you just stated, is determined as something that's transporting goods, which I'm not transporting goods.
I understand your position, and I can tell you that that position doesn't happen to be legally correct. But go ahead.
So you're basically stating that there's a misinterpretation of what's in black and white?
No, I'm telling you that you have misinterpreted the application of 18 USC 31A6 and 769 F second or Fed second 1344.
Okay,
But
well, I see
I've
what this
heard
is
your
going.
argument.
So there will be no further arguments because I see that you're not going to agree to, because like I said, I've given it to you, the cases where they're like Shapiro v. Thompson, where the U.S. Supreme Court has said that a driver license is not a requirement, that you're trying to convert a right into a privilege, to which is covered by Article 1, Section 8,
Well,
to which
I'll ask you this. Is that right, the right to travel?
that is a right to travel, convey, however you want it, by the U.S. Constitution.
What you just told me was that somehow but regardless, am trying to convert a right into a privilege. Now, the question I have for you is, what right has been converted to a privilege?
My right to freely travel unencumbered
very good.
and
Now,
unfettered.
I will ask you this. How is your right to travel removed by receiving the citation?
By trying to require me to have a license to operate a automobile, which is my private vehicle.
After listening to all arguments, Magistrate Heist delivers a firm ruling. Williams is responsible for both civil infractions, totaling fines for lack of insurance and expired registration. The judge provides clear reasoning, explaining that rights to travel exist but do not exempt citizens from following motor vehicle laws. The host emphasizes how the ruling exemplifies judicial patience and adherence to law, contrasting the legal clarity with the defendant's misinterpretation of rights versus privileges. This segment demonstrates the law's adaptability to unusual arguments while maintaining fairness.
Registration to be current do not run in violation of any right to travel under the Constitution or the United States Supreme Court decision that you have cited. In fact, Michigan courts have held that essentially the right to travel means the right for you to move from A to B, not the right for you to travel from A to B under your most convenient way. So you could walk from point A to B all you wanted. You could take a taxi or an Uber or a plane or a train or a bus. But if you wish to travel by using a motor vehicle, the Michigan laws are applicable and don't unconstitutionally interfere with the right to travel. It doesn't convert the right to travel into a privilege. You are not denied the right to travel. You may be denied the privilege of traveling via a motor vehicle that you are operating. So
Okay, so I
that
stop
is
you
that is what the law says, and that's what I'm finding. Is there
Okay,
anything else you
so
want me to consider about that finding?
Shuttleworth v. Birmingham, US 147. Do you mind telling me what the US Supreme Court ruled in that?
US 147 doesn't give me the site of a case. That's an
Uh,
incomplete site of a case. Okay.
it was Shuttle.
And
I said
if you wish me
I
to
said
consider the case,
Shuttleworth.
why don't you tell me what was at issue in the case and what year it was decided?
I said Shuttleworth v. Birmingham, US 147, 1969, where it
Okay,
says
hold
no
on. US
license.
147 is not a complete site. The way you cite to a case is by name and then volume number and then the name of the publication and then the page number. So for instance, when you said 769 Fed 2nd 1344, what that means is volume 769 of a book or volumes called The Federal Reporter, second edition, at page 1344. So when you're asking me about this most recent case that you've talked about, what you said was US 147, I think. That's not the citation to a case. So you're going to have to tell me more about that case. Who were the
Okay,
parties to that case and what issue was before the Supreme Court in that case?
okay, so you didn't hear me cite the name of Shuttleworth v. Birmingham?
I heard you say the name. That doesn't
Okay,
tell me what, that's not a complete cite of the case.
all right. Do you not have the documents that I filed when I filed to say that I want?
The video closes with the host summarizing all 4 sovereign citizen cases, highlighting patterns of noncompliance, creative legal interpretations, and the consistent application of courtroom rules. Viewers are reminded of the distinction between enumerated rights and statutory requirements, the authority of judges, and the importance of procedural adherence. The host ends with a call to action to like, comment, subscribe, and appreciate the sponsor, tying together entertainment, education, and viewer engagement.
Not include any person who solely transport his own property and who transport no persons or property for hire or
Where's that
compensation.
citation from?
Okay, I just appeal it, and that way I can make sure all citations are.
That's fine. I mean, the idea is I can't look up what you're telling me, right? Without a proper citation. So you can read, I mean, for all I know, and I don't mean this, I'm using a farcical example. For all I know, you're quoting the municipal court in Honolulu, Hawaii, which has no jurisdiction over Michigan.
It's
right?
understandable.
I don't know.
So I would cite Payne v. Massey, 19196 Southwest 2nd, 493, Texas, 273.
Okay. Well, and I can tell you that Texas law, a court interpreting Texas law, that decision wouldn't be controlling on a Michigan court. But that's fine. I think I understand where you're going. If you want, I don't need to consider anything else. I'm just asking you, is there anything else you want to present to me?
If you're not going to consider anything else, then we can proceed on to your ruling, of which I know you're going to find. So, and like I said, like you said, I have a right to appeal it. So
yeah, and I'm willing to listen. If you're going to quote something, I need to know what you're quoting, and I need a proper citation so I can look it up myself, right? Because otherwise, people could just run around quoting Mickey Mouse if they wanted.
Right. Okay. So
nothing against you. So the question to you is, what else do you want me to consider at this point that you haven't yet told me?
Okay, Zobel v. Williams, 457 US 55.
And why are you citing that case? What is it telling me?
Because it states that, let me see the above, blah, 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 to travel unencumbered and fettered on common public way or highway, which is their